Just some quick background on me. I've been with the department going on 25 years. Most of my time was spent in litigation, and I've been the chair of the Board of Appeals for about 2 years now. I was a board member previously for a few years, and now I'm the chair. I thought I knew everything that was going on, but my eyes have really been opened. Um, I if you ever have any questions, I'm just going to state this at the beginning to say, please reach out to our office. I feel like our office very specifically should be one that is really open to any taxpayers representatives to please call our office if you have any questions. I think, have a very good sense of the department as a whole. And so we can really help answer questions, not all questions, but when you're coming to the board, if you have a specific question about coming to the board, we are happy to field those questions. Next slide. Okay, so the Board of Appeals is created and operates pursuant to our enabling statute, which I've cited, and you can hit the link if you want to ever read over our authority. And our mission basically is to provide a forum to resolve final tax liability by a showing of reasonable cause to reduce or abate penalties or financial hardship to compromise the amounts that are due to the state. Those are really the two avenues that the Board of Appeals will handle. Next slide. Okay, so generally, what is the board? The board consists of three board members, all that are appointed by the director. And so me, I am one chair. I have one member. I'm the chair, and so I'm responsible for overseeing our um, daily business affairs, including policy-related matters, resolution of our cases, and case management. The two other members directly participate in the board's decision-making process and reviewing those files. So there is a threshold that of cases that are sent to the other chair members based on amount of what's at issue or what we're compromising. So right now, like I said, I am the chair of the board, and my other two board members are Stephen Hayes, who is the collections program manager, and Alexis Overstreet, who is the deputy general counsel for sales and excise tax policy. Next slide. Okay, so what kind of cases does the board hear? So pursuant to our enabling statute, our jurisdiction is really limited to final assessments. And so very similarly to what Melanie had touched on, those are assessments that can no longer be challenged on the merits because the protest period has expired or the merits have been adjudicated by way of some other final judgment or administrative decision. And so, just to touch on that a little bit, I do find um, we do get some petitions that are filed with us where the taxpayer is um, really challenging the underlying tax. And so we have a very specific conversation with the people who file those petitions because if they're really challenging the underlying tax, then the Board of Appeals is not the place for you. You need to be with either the Office of Administrative Hearings or the Tax Tribunal or Circuit Court. However, a lot of times when they get to the board, their protest period has already expired. So then your avenue at that point would be um, going to the chief ALJ, Melanie Annealy, and asking for that late discretionary hearing that she had talked about. And so, depending on what that decision is, so if she does grant you a late discretionary hearing, then the underlying tax liability can be heard on the merits of whether you owe that particular amount of tax. However, if she does not grant you a late discretionary hearing, then you can come back to the board if again, if you're coming to us on a reasonable cause for abatement of penalties or offering compromise. But that is going to be based on then ability to pay, no longer looking at, and really we are not charged with that underlying tax liability. So I had just mentioned that we are strictly limited to final assessments. There is an extremely rare circumstance where either the director will order us to assume jurisdiction, or all three board members need to agree that some special circumstance is occurring that in the best interest of departmental efficiency or interest in justice, we will take, and this is what's referred to as special jurisdiction. In my experience, it's very rare, and it is usually results from a multiple rare circumstances kind of all happening at once, almost like a perfect storm. And so at that point, the department will take special jurisdiction uh, based on the request or on our own three panel agreeing on it. Again, that's very rare. Next slide. Okay, so what types of cases do we hear? So we hear offers and compromise, and those are cases where the taxpayer is again seeking to reduce the amount of um, tax, penalty, and potentially interest that's owed. And that's based on a showing of uh, financial, medical, or other demonstrated hardship. Um, and then the other avenue for the board is reasonable cause. And so that's penalty relief. And a lot of times, penalty has been addressed, perhaps in other units. That is one thing we're trying to right now kind of get a little bit of a better handle on, because uh, 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 if reasonable cause has been looked at another by another unit in the department, then the standard isn't going to change once you get to the Board of Appeals. So we're really trying to take a better look at reasonable cause and what the basis is of why you're coming to the Board of Appeals for that. Okay, so a caveat on the offers and compromise. So we are, the director is the only person authorized to compromise debts due to the state following a review of the Board of Appeals. And so in that respect, it is the director and not the board that has the final say in these matters. Now, for practical purposes, I have authority under a certain amount, and over a certain amount, it will go to the director for his personal signature and review. Next slide. Okay, I talked a little bit about reasonable cause, but we are really looking at reasonable cause, just like any other unit of the department should be. And so reasonable cause generally doesn't include interest relief. However, we are the only area where you could potentially get interest relief. So what that review entails is really taking a look at whatever the matter is holistically, and that includes, the timeline of what has happened in your particular situation, and since interest does represent the time value of money, I am not, and nor are my hearing officers, very quick to recommend interest be abated. However, if you can demonstrate a situation where perhaps there was an extreme delay in getting whatever it is you're here at the board to be resolved, then I will consider it. Next slide. Okay, so just to kind of give everyone, it seems like we do get quite a few phone calls of, I just filed my petition, so how long until I get a result? And so just I would like to set expectations. So right now we are actually over. I think when I wrote this slide, it was about a month ago. So we are actually over 1,200 cases, and we're only into what, mid-September. So I anticipate we'll probably finish the year with about 1,500 cases having been filed with the board. So and we do make every effort to resolve all the cases in a very efficient manner. And so what that means is that I'm taking a very close look now at cases that come in, and I am assigning them, if it's a, let's for example say, a lower dollar reasonable cause case, I am trying to get those kind of in and out of our office as quickly as possible, because the time and review that those take isn't as extensive as, let's say, a high dollar offer and compromise. So I am taking a very, I think, practical and efficient look at those cases that are filed. However, if you call our office and ask for a timeline, it's very hard to give you one, because it just kind of depends on the specific facts of your case. However, there are some circumstances that, when people call our office, warrant an emergency consideration, such as serious illness, um, foreclosure, or that you're selling your house and there is a lien attached at that time that you're trying to resolve with the board. And so please call our office and let us know. However, I cannot guarantee that we'll address your petition as quickly as you want. I will give my best efforts and I will listen to your reasoning. However, I will also say that um, there are a lot of people who have emergency type situations. So know that you're not the only one in that boat. And so I really am thoughtful in uh, um, how I assign cases, and if it is truly an emergency situation, I will, uh, put you forward on someone's docket. However, um, please don't be calling me up with every client, and every client has an emergency, because I'm sorry to say that just can't be. So, next slide. So what kind of cases do we not hear? So we do not hear release of we cannot hear release of liens. However, what happens a lot of times is there is a lien on someone's property. And so if they have a petition filing with the board, then we will help resolve whatever whatever liability caused that lien to be placed on the property. And then we do help, we can help put you in contact with the right people who will help with that release of lien, but we cannot do it ourselves. There is a specialized unit for that. We cannot reverse a order of revocation. That is the Office of Administrative Hearings. And we also cannot stop the seizure, a federal or state refund. So the department only issues refunds if the taxpayer has no outstanding debt. Otherwise, it's applied to that outstanding debt, and we cannot, the board cannot stop that. Next slide. The other types of cases that are types of issues that come up that we do not handle are these stop enforcement action when funds become available. There's really no way for us to do this as we don't know when they actually will become available. So we don't have any authority there. Again, late discretionary, like I said, we refer the taxpayer POA to the Office of Administrative Hearings for a protest or for if they're contesting the underlying liability. And like I said, if you are not granted a late discretionary hearing, then you can come back to the board. Okay, next slide. Okay, so now you've gone ahead and you've decided, yes, the board is where you need to be. So what do you need to fill out? So the first thing you need to fill out is a BOA1, and that's the Board of Appeals petition. And that you can find it on IDOR's website. We can email you the link. We can send you the PDF, but it is readily available for you to find on your own. And so you fill that petition out. And if you're filing an offer in compromise, then you will also, depending who you're filing on behalf of, if you're filing on behalf of a business, you'll file a financial disclosure called a BOA5. If you are filing on behalf of an individual, or you are the individual, that is the BOA4. And again, I've attached the links to all three of those forms for the board. And so if you are filing an offer in compromise, we do ask for supporting documentation, including but not limited to your federal and state tax returns. And I would like to note here that when you're sending us your federal tax return, that should include all schedules and all statements. With regards to 6 months worth of bank statements for all the accounts that you listed on your BOA4. Here, I would like to highlight, it is not looked favorably on by the board when we see statements, when the hearing officers are reviewing the statements and they see other accounts that are referenced in accounts that have the statements have been turned over, and then we see that there are other accounts that have not been turned over. So that will only cause delay, and it really not only slows down the process, but doesn't, look good for you. And then also your most recent pay stubs or 1099s, and then any information, if you have it, with regards to a current federal offer in compromise. However, here I would like to say just because the IRS has granted you some sort of compromise, let's say it's on, uh, for example, let's say withholding, and let's say the IRS has granted some sort of um, offer on that withholding, we are not bound by what the IRS does. So we take an independent look at what your particular facts and circumstances are. And so very often we do not follow what the IRS has done because I'm not sure what information they're looking at. So I like our hearing officers to um, look at what we deem important and necessary to review. Next slide. Okay, and so the board, we may require some additional documentation, again, depending on this on your particular circumstance. So if you are alleging there's medical reasons why you are suffering a hardship. Not necessarily asking, we don't want any personal information, but some proof that, you are uh, incurring a lot of expenses, or that you are unable to work because of an illness. It's just something to substantiate your claim that why you are medically, not able to pay the state back. Um, and then we will ask that. And if you don't respond, then that could be a reason to dismiss your case. And so when we send you a letter for additional information, please take that and respond to it as quickly as possible. Again, we have a timeline that we think is reasonable. And if there's something that you can't respond to, or there's a reason you can't, then all you need to do is give that falls under our jurisdiction area. Just give them a call and say you need some additional time to respond. But if you ignore what we've asked for, then that could be a reason to dismiss your case. Additionally, you do not have to have a power of attorney to be in front of the board. However, if you do choose to have an attorney represent you, then the attorney needs to have a power of attorney, a valid power of attorney on file. And so that was a little bit, I think when I first started here, that was a process that needed to be ironed out a little bit better. But we have the department has a very specific unit to do that. And so we will just refer you to that unit. And once the power of attorney is on file and valid, the only thing that uh, will happen if there's not a valid power of attorney, then any notices from our office will only go to the taxpayer. So if you are an attorney or a CPA, or you're representing this client, make sure it's valid. Otherwise, you will not be being sent those notices. Next slide. Okay, so how do you file a case with the board? Um, I think that our number one preference is really to email your petition and your supporting documents with our general. It's that mailbox that I've posted here, or that I've referenced here, is monitored on a um, uh, not only daily minute. We are constantly monitoring that mailbox for what's coming in, and so that is our preferred place for you to file your petition. We also accept faxed documents. However, I will say that the the fax really just goes to into that Revenue Board of Appeals mailbox, and then it's I would say it's highly discouraged, but I know there are some taxpayers out there that feel very comfortable with paper. And so if you really need to, you can mail it in. But I guess here I would really discourage it just because it's so much quicker and more efficient for us to receive things via email. But please, and I know there's a lot of you out there, um, we only need it once. Once we've received your petition and it's docketed, you will receive a automatic notice of receipt, so you know we've gotten it. Um, it slows our process down if we're getting, that petition from you in like 3 different ways. So we only need it coming into one, either our mailbox or our fax or hard copy mailed. We don't, we discourage filing more than one. So just pick your place and file it there. Next slide. Okay, so once we've received your petition, like I said, you get a notice of receipt that's automatically mailed out to whomever is either the power of attorney, valid power of attorney on record, or the taxpayer. Um, and then once that's docketed, and I think maybe in the past, um, that process was maybe a little bit longer than it is now. My office has worked very hard at really when we get petitions in, they are done almost on a real-time basis. We might have, depending on the day, we might get more in, and that might cause some overflow to the next day. But we strive very hard to get our petitions docketed in real time. So when you file it, know that our office, it will be docketed either that day or the next day, depending on our flow of work. Um, and then once your case is docketed, then my jurisdiction unit will look it over, and they look it over for kind of, is it a finalized liability like we talked about? Is it pending somewhere else? Because you cannot be pending both in administrative hearings or the tax tribunal or circuit court and at the board. So again, that liability all ties into that finality of it. And again, I think that it is the IRS that requests things sent in triplicate. We do not want that. We just need one copy sent one place. That's it. Um, and then the other word of caution here, we've seen this, like there was maybe things weren't nailed down as they should have been a little bit, but we need that petition to be signed by the taxpayer. It's not signed by the POA, it's signed by the taxpayer or an authorized representative. So if it's unsigned, you will get an email from us letting you know it's not going to go any further until we received that signature. Next slide. Okay, so one of the areas on the board petition, and we get a lot of phone calls on temporary restraining order. And so just to clarify, that simply just means what the board has authority to do is to tell any other unit of the Department of Revenue, stop any other enforcement action, any collection action at that time. And so, because now the taxpayer is trying to work something out at the board. And so, what a TRO does is it will say, stop the wage or bank levy, and while this is under review with the board. However, I will also say that a lot of times it seems to me that some taxpayers or representatives think that a TRO is automatic. It is not. I and my staff look very closely at the situation to see if it's in the taxpayer and the department's best interest to stop collection action at this time. There are a lot of considerations that go into it, and so it is absolutely not automatic. And so if we do find that there is a reason to enter a TRO, it will be unconditional, either conditional or unconditional. Unconditional just does not require any further payment, either on a monthly basis or towards the tax that's involved, and that would be conditional. And so, what we look at for a conditional TRO is a, usually a lump sum payment towards the underlying tax liability at issue, either made in one payment, or sometimes we make it in, a couple of payments, and then thereafter a monthly payment on that TRO. And so again, it's a very specific review to the not only the taxpayer but the underlying liability. And again, keeping in mind, we are looking out for, the best interest of the state as well as the taxpayer who's coming to us to ask for help. Okay, next slide. Okay, so what a TRO does not do, it does not toll the statute of limitations. And it will not prevent the department from filing a lien. What it does is stop collection action. And so there are some things that cannot be stopped, and that's if the department issues refunds only, again, if there's no outstanding balance. And so we will not issue a refund. A TRO will not stop that either. And the department will offset that refund by whatever is owed if it's coming in from a state, federal refund. Next slide. Okay, a TRO does not overturn or reverse any liens, levies, revocations. I think this is another kind of area, if I could put a word of caution out there, that a lot of times, if your client is really wanting to come to the board, sooner is better than later, because if collections has already started down their path, it's rare that I will stop it if it started before a petition has been filed. So I like to look at where the taxpayer is now, and then going forward, if something's already in motion, again, that's another consideration that we take into account, because collections is they're doing their job too. So regardless, if a TRO is conditional, that means that you're making a payment. If it's unconditional, no payment. However, in both circumstances, you need to make sure that you are remaining current with your any future liability, because if you're not, then we'll revoke the TRO, and then you can still be at the board, but we will also let collections know that there is no more TRO in place, and they can continue on with their collection efforts. So a lot of times taxpayers will call and ask to add additional liability. That could result in, perhaps if you were on an unconditional TRO, making it be conditional, or increasing the conditional TRO if you're trying to add additional liability. Next slide. Okay, so now the board has accepted my case. Now what? So another area on the BOA one is you can request a hearing or not. Basically, waiving a hearing just means the hearing officer will decide on whatever information that has been sent in, and any other information that the board has access to. Requesting a hearing, that's fine. The hearing officer will schedule a hearing with you. And again, prior to the pandemic, most of those hearings, I think, were held in person. Now it seems like they're held over the phone via WebEx. However, they can be held in person as well, and that is either in our Chicago office or in our Springfield office. And so we do whatever is necessary to accommodate your request. You are always entitled to an in-person hearing. It just seems like things run very smoothly with WebEx hearings. And again, the hearing isn't used in the same context as an administrative hearing. There is no evidence here. There is just what you chose to give us to help us make a decision on whether or not either you're entitled to reasonable cause abatement of penalty and or interest, or if you are entitled to some sort of relief via an offer and compromise financial hardship. Next slide. Okay, and so with the hearing, a lot of times what the hearing officer will do is reach out, again, depending on the complexity of what is happening in your case. Maybe one or two hearings might be necessary in order to kind of get any further questions answered, any additional information that might be required by the hearing officer. Um, and Here's the thing. We don't have subpoena power, nor do we want it. So this is a very different venue. And coming from my background, this is a very different venue than hearings. When if we ask in discovery for information and you don't provide it, we will issue a subpoena to get that information, either a third party or the end result is to exclude evidence if it's not provided. The Board of Appeals is very different. It's not litigious. And so if you choose not to give us information that we're asking for, most likely that is not going to be in your favor. We're asking for it for a very specific reason. And when you don't provide it, that is completely up to you, but it usually isn't. It isn't good for you. The hearing officer will just make a decision based on all the information that was provided, but also information that the board has access to. So if you think, oh, I have, for example, I have an account, I don't want the board to know about it, I'm just not going to present that information. And in some way, we can see that that account hasn't been disclosed, then, again, that's an example of how things won't, well, then we're not sure if you really are entitled to an offer and compromise. And so those are the factors that our hearing officers are looking at. Next, if it's a decision based on a reasonable cause, you go back a slide, I think. Okay. Thank you. If it's a reasonable cause, again, those are really under the same type of review as the other units that provide reasonable cause abatement of penalties, so we look at them in the same way. Okay, next slide. Okay, so one, we can I've already gone over this. We will not go over anything other than a finalized liability. You have other places to do that in the department, and we will not extend or waive protest period. Again, I've gone over other places that within the department you have that option, and we will not interfere with a federal or state offset program. Next slide. Um, Again, a couple things we can't do is overturn a criminal conviction. I think Michael had gone over outside collection agency fees. We have no control over that. That is contractual. Um, we will not rehear a board decision without additional information or evidence. So while there is, you can come before the board again, that's fine. However, if you don't, just because you don't like our decision, doesn't mean that you can, if you don't have something more, when you refile, we like to be consistent with our decisions. So the decision will most likely be the same without some other substantial or material change in circumstances. Um, Next slide. That is it for me. Again, if you have any questions, always reach out to our office. Thank you.